I think there's memes out there in the press that this was like a big shift when this announcement came through. And I think there's ways this could turn out well. But I don't think that having the view that this was a big shift is really the right way to be thinking about this situation right now. I think keeping the pressure on is the right way to respond to this, rather than think, oh, good, we won, the nonprofit's in control, we can all sleep easy at night. I think there's still a lot of work to be done. There's a way that this moves forward where you're on a slippery slope to the profits becoming the end instead of the means. And we want to make sure that they remain the means and not the end. It's why OpenAI set themselves up the way they did to begin with, right? Like they understood that this was a unique situation and they put in a unique corporate structure, a very thoughtful way of trying to put these safeguards around it. And so we're just really concerned with trying to protect those now.
If someone was just trying to steal a whole lot of stuff from you, and then after a lot of public pressure, they decide that they're not going to try to steal that stuff from you anymore, they are going to propose a different plan, a different very complex plan that you find it quite hard to understand. I think that it remains sensible to have a defensive posture here and not to assume that without any further scrutiny or any further discussion that the better angels will win out and all of these great things will happen by default.
This is also an opportunity for them to do better, find things that aren't in the existing charter that would be good for the world and then write them into the articles. The nonprofit board members owe a special fiduciary duty to humanity as the beneficiaries of OpenAI's charitable purpose to ensure that AGI is safe and benefits all of humanity. That mission applies to what they do right now, right, in approving whatever restructuring goes through.
Today, I'm speaking with Tyler Whitmer. Tyler was a partner at a law firm called Quinn Emanuel for many years, and more recently has been the founder of Legal Advocates for Safe Science and Technology. But we are speaking with him today because he's a co-author on a letter to the Attorneys General of California and Delaware, which should be coming out approximately today, about OpenAI's announcement that its nonprofit is supposedly going to retain control of the business, which the letter argues is very much not necessarily true by default. Welcome to the show, Tyler.
Thanks for having me, Rob. Appreciate it.
So my goals today are to explain to everyone very clearly as possible, why it is that OpenAI's big announcement last week that it supposedly wasn't going for profit anymore, why that was probably very misleading, and in your view, maybe it was actually no improvement on the plans at all. Then we're going to say what it is that the Attorneys General of California and Delaware and the nonprofit board members should insist on OpenAI doing to ensure that the public interest gets defended. To launch us in, though, your letter says the updated proposed restructuring is identical in most respects to the original proposal. Why do these new plans not necessarily make much difference?
Yeah, so I think it could be useful to take a step back and look a little bit at the status quo, which is on the issues that we're going to focus on, that we focused on in the letter and we're going to focus on today, that the nonprofit has very direct and immediate control over OpenAI's for-profit. And they made an announcement towards the end of last year that they were going to change that and in a bunch of different ways. And then on Monday the 5th, they made an announcement that the nonprofit was going to retain control of the for-profit entity. And I think the real crux of that is, what does it mean to retain control? And by default, the control that they might retain really doesn't approximate the status quo at all, and that's what we're concerned with.
I see. So currently, as I understand it, the nonprofit entity has basically total control over the business, which is an LLC. I guess occasionally we'll call it OpenAI LLC, but basically that is just the business part of it. It's a subsidiary of the nonprofit. They just get to control it completely. Why is it that on the new plans, the nonprofit will probably lose the ability to actually direct what the business does?
Both the original restructuring plan and the revision that they announced last week, the LLC that you just described, which is a limited liability company in Delaware, would convert into what's called a Delaware Public Benefit Corporation. The way that it's structured right now, the nonprofit is the manager of the LLC and has direct and immediate control of everything that the LLC does. If the LLC converts into a public benefit corporation, then control could mean something like the nonprofit retains the ability to elect the board of directors of the public benefit corporation, but it would not have the same kind of direct and immediate control that it would have with the LLC setup.
Yeah, and so electing the board of directors why isn't that a sufficient level of control?
Yeah, I mean, I think one way to think about it is, how is this actually operationalized in areas that we care about? So, for example, if OpenAI LLC currently were planning to do something like release a model that appeared to be unsafe, the nonprofit would have the power now to just step in and stop that from happening very directly. And that's a product of the kind of immediate control it has by virtue of being the manager of the LLC. In the public benefit corporation situation, using that same hypothetical situation, if there's a model that's about to be rolled out that's unsafe, the nonprofit would not necessarily have the ability to step in and stop that from happening immediately. They would be able to elect a board that they would hope would do the thing that they want to do in that situation and keep that unsafe model from being rolled out. But they wouldn't actually be able to step in and stop it immediately.
I see. Yeah, and from reading your letter, which people can go and read, it's only a few pages, and it's a very entertaining and I think a pretty straightforward thing to understand. They actually might not even be able to do that. It's unclear, in fact, that they would have almost any influence potentially over what the business could do by default. I think one thing that I didn't understand until recently is that the reason that OpenAI, the nonprofit, has so much control over the business today is that they have this whole set of binding legal agreements that were instituted at the outset of this entire arrangement, which basically are quite non-standard, and they give the nonprofit the ability to intervene in all of these ways and to have this kind of strong level of control. And if the LLC were to convert into a Delaware public benefit corporation, which I guess has actually always been the plan both before and today.
That's right.
Potentially all of those contractual agreements that were very carefully arranged in 2019 to ensure that the nonprofit mission would take priority over making money, that would all basically be swept away by default. And so you would be reverting to a situation where the nonprofit board would have like a more typical level of control that a shareholder might have within a company, which is radically less than the kinds of direct managerial control that they have over it today. And one crazy thing is, right, this agreement between the nonprofit and OpenAI, the business, which actually, I guess that is the asset that the nonprofit has that allows it to pursue its charitable mission, that allows it to pursue its goal of ensuring that AGI benefits all of humanity. That is the chip that it has to play. It's the way that it defends the public interest. That document itself is not public. The public does not know what it owns, what rights it has. And in fact, it could lose all of the things that are in that document and maybe not even realize, because it's never actually been declared what kinds of rights the nonprofit has as part of its, as its like owner, as the owner of the business. Have I understood this right?
Yeah, that's right. I mean, the operating agreement of the LLC that is the current for-profit entity is not a public document. Now, OpenAI has described that document on their website in some amount of detail, and it's sort of enough detail that you get the sense that it is a bespoke, unique situation where there is an awful lot of control and power given to the nonprofit board. And LLCs are sort of like designed to be an extremely malleable sort of situation. And there's more flexibility with what you can do with an LLC than what you can do with a PBC. So one of the concerns that we have is in converting from an LLC to a PBC, you sort of remove some of that optionality. Like there's more you can do to structure the LLC exactly how you want it than with a PBC. And so you're taking away some of that ability to structure it just the way you want it. One thing that a PBC could be good for, though, is the sort of the equivalent of the operating agreement for a PBC would be the Articles of Incorporation or the Certificate of Incorporation, and that would be a public document. So to your point, we know a little bit about what's in the LLC agreement by reading OpenAI's website. We don't know everything about it. I think it would be really good for the world if we were able to, hold up what's in that LLC agreement and the kind of control that exists there. Right. And hold that up against whatever they put into the PBC's, if they go through with the restructuring, whatever goes into the PBC's certificate of incorporation, and make sure that what's happening with the PBC and the relationship between the PBC and the nonprofit gives the nonprofit at least as much control, right, over the PBC. And I shouldn't say this, like, it's not so much about control every time, right? I think what's really important to us here is that there be the primacy of the nonprofit's mission, which is to ensure that AGI is safe and benefits all of humanity, and that mission and the primacy of that mission is enforceable by someone with the ability to really enforce it. Right now, the situation is that the LLC agreement has been written in a way, we're told by OpenAI on their website, it's been written in a way that enforces that primacy of the mission. And then because it's a nonprofit, the attorneys general of California and Delaware, the reason we're writing the letters to them is that they have very direct oversight and ability to regulate the nonprofit because it's a nonprofit. So what we want to make sure happens is that whatever happens with the restructuring, we end up in at least as good a situation we are now. And I think you're right that like having some transparency into what the actual details were of that LLC agreement could help us do that.
Yeah, I feel like I'm taking crazy pills when I say that the whole thing that's under dispute here is actually not public. It really feels like it's a bare minimum probably for the attorneys general to insist that, given that there's so much public interest in this, it is such a matter of enormous public concern, and it's impossible for us to assess whether, in fact, the nonprofit is being ripped off, whether its mission is being pursued, without knowing what the status quo situation is, without knowing what rights and what control they currently have. That surely that agreement, or at least large parts of it, should be made public so that people can assess whether the new situation that's being proposed is as good or better, or actually worse and maybe shouldn't be legal. Yeah. Cool.
I think it would be great. I think it would be great for them to make that more transparent. I think that would be good for the world for sure.
Nice. I think one other thing, just quickly before we go on and explain more of the details here, is that your letter focuses basically on this question of control and managerial control and primacy of the nonprofit's charitable purpose of ensuring that AGI benefits all of humanity. But there's two other things that are changing here. I think either definitely or almost certainly, which is that the profit caps on future investors and probably existing investors will be removed, which is a big loss, I guess, to the nonprofit, because that previously those profits would have gone to them. And also currently I think it is probably the case that the nonprofit has basically the right to operate and make decisions about how any AGI that OpenAI develops is used and applied. And that is almost certainly going to go out of the window. These are big concessions from the nonprofit that they're making, and in order for this to make sense in pursuit of their nonprofit mission, they ought to receive some substantial compensation for that. But we're going to kind of set those issues aside in order to just consider these issues of control, which are themselves both important and like quite challenging to understand. Okay, so before we get to the solutions, let's lay out precisely why it is that the nonprofit would, by default, basically lose control of lose the ability to determine what OpenAI, the business, did on the plan that OpenAI has sketched out. And this was true before the announcement last week and remains true after that announcement. The first thing you state in the letter, there's three issues that you raise. The first one is OpenAI's business directors would not have a fiduciary duty to advance the charitable mission over investor interests. Yeah, can you explain that, and what duty would they have instead in this new world?
Yeah, so with a nonprofit, the nonprofit directors have a special fiduciary duty to the beneficiaries of the nonprofit's purpose, the mission of the nonprofit. And that's very clear, and that's enforceable by the attorneys general. If the nonprofit's control, with a public benefit corporation, even if you wrote precisely the nonprofit mission into the public benefit mission of the PBC, by statute in Delaware, the PBC's directors still have to balance that mission with the pecuniary, the financial interests of their shareholders. And there is no special fiduciary duty to the beneficiaries of the PBC's mission the way there is with a nonprofit. So you really are changing the duties that are owed to the public by changing it from a nonprofit to a PBC.
Right. Yeah, so I think it's useful to imagine here, or to conceptualize it. You've got the nonprofit at the top here as a shareholder, or having some sort of voting rights over the new public benefit corporation, the PBC, this new entity.
Yeah.
Now, the nonprofit has its own charitable purpose, and it's got its own duties, which is to pursue that charitable purpose as much as it can. In this new situation, you'll have the PBC under that, but it has its own quite separate obligations that it must pursue, that its directors must pursue, and that I guess its staff must pursue by extension. Now, you could imagine a situation where the nonprofit, I think we're not even sure whether it's actually the case that the nonprofit would get to determine the board, the board of directors of the new business. But let's say that it does have the ability to fire them and replace them. The directors of the business, let's say that they started doing things that were excessively pursuing profit and not pursuing the public benefit in the views of the nonprofit. The nonprofit could say, vote to remove the directors or remove some of the directors and replace them with other directors who it thought in their hearts wanted to pursue the nonprofit's purpose of ensuring that AGI benefits all of humanity. But as soon as those people are directors of the business, they have new different legal obligations from that. Even if they wanted to pursue the nonprofit's mission of ensuring that AGI benefits all of humanity, in their role as directors, they have to follow the fiduciary duties of the PBC, of the Public Benefit Corporation, which is to balance profit against the other purpose of the organization. I guess we don't know exactly how that will be stated. And so even if they wanted to, say, stop something that they thought was too harmful to the world relative to the amount of money that was made, they might not in fact be entitled to do that. And if they tried to do it, and you can imagine the not-for-profit keeps firing the directors and replacing them with new people, and every time they just have to do the same thing, they now have to pursue the purpose of the Public Benefit Corporation. If some of them didn't, and in fact they instead just went with the purpose of the nonprofit that had put them there, then they would be at risk of getting sued by the for-profit investors who would say, no, we're getting ripped off here. You have to follow the purpose of the Public Benefit Corporation. Have I understood all of this correctly from the letter?
Yeah, I think that's about right. And, there's things you can do, like as I said in the certificate of incorporation of the PBC, that could change that. But if you just did sort of like an off the rack, as they say, PBC certificate of incorporation, the description that you just gave is accurate. And, one way to think about it is, right now with the LLC set up, the nonprofit basically has its hand on the lever and controls things directly. And with an off-the-rack PBC setup, you're going to make that a situation where the nonprofit doesn't have its hand on the lever anymore, but it gets to decide whose hand is on the lever. But there's still that, one step distance from actual control. And that is enough, in our view, to really put at risk what's important here, which is, again, sort of a legally enforceable primacy of the nonprofit's mission over the interests of shareholders and any other interests that might be there. Once you set up that, once there's that one step removed from the hand on the lever versus, controlling who has their hand on the lever, it disrupts that enough that it's a problem for us.
Yeah, right. So, and the second point that you raise is that OpenAI, the nonprofit's board, would have substantially less control after this than it does today. I guess we've somewhat covered that. Is there anything more to say about exactly how it would be losing control?
Yeah, I think it's what you just described, right? Which is really that it is no longer directly controlling things. It is controlling. It is maybe having power over who controls the thing. And ordinarily, depending on how this is set up, we was sort of we assumed in the letter that the nonprofit would retain what's called voting control, right? So they would have the ability to elect the directors. There's some credible reporting out there that it's possible they would set it up to where the nonprofit doesn't even have that power, or doesn't have power to, for example, hire and fire the CEO, which is, normally a controlling shareholder would have the power to elect the directors, and the directors would have the power to hire and fire a CEO. I mean, obviously that's the kind of control you would need at a very, very, very bare minimum, and would not be enough to approximate the current situation.
Yeah, it is interesting. I mean, so we're assuming that they're not going by default to go out of their way to make these binding, bespoke, unusual arrangements that would preserve the current level of control that the nonprofit has. But I feel like that's a reasonable assumption, because they haven't said they're going to in any way. They've never indicated that is going to be the case. And two, so many of the different interest groups here would really like that not to be the case. All of the for-profit investors who have tens, hundreds of billions of dollars at stake, and I think are heavily involved in this process, would really love to remove all of those limitations. And I suspect that there's a good chance that people who have that level of motivation might definitely get their way. Yeah, you say, I think in the we assume below that OpenAI nonprofit would have voting control of OpenAI, the Public Benefit Corporation's board, in some way. What such control would entail appears to be unsettled, however. For example, credible reporting states that it has not yet been decided whether OpenAI nonprofit's board would have the power to even fire OpenAI's board of directors or executives. Isn't that kind of, I mean, I guess they've said this very vague thing, that the nonprofit will retain control. Could they really pass off minority voting rights without even the ability to change the board of directors, like the main thing that shareholders in general are able to do? That would be retaining control? That would just feel like the most flagrant attempt at fraud. And I mean, I find it hard to believe that the attorneys general would ever sign off on such a crazy arrangement.
I mean, I agree with you. I think most folks who are familiar with the way businesses work, and certainly most lawyers, when you read retain control, the baseline that you would assume is either by a majority vote or by some kind of special class of shares voting, that they would have the ability to, hire and fire directors. Like that seems like the absolute baseline. So I agree with you. I would be shocked, and it would be pretty egregious if they tried to do something less than that. Although, like again, I think this is an article in Bloomberg that is referenced in the letter, where it at least seemed like that might not, might still be on the table, which was pretty shocking. Yeah.
Yeah, I wonder, I guess if you were being really sneaky, you could try putting forward that as your initial proposal, and then maybe that's the thing that gets disputed. It's like making an outrageous initial bid, basically, in the hope that then shapes people's baseline expectations, even if you don't actually expect to get it through.
Yeah, no, that's why we've been trying to sort of frame everything up as best we can, sort of look, in the original not-for-profit gain letter that came out in the middle of April, we really walk through the very intentional process that OpenAI went through to sort of bind themselves to the mast here, right? To put in all these governance safeguards based on the current structure, right? With the LLC and the nonprofit is directly controlling the LLC, so that they could really be sure. I mean, this was a years long process that they went through to button this up as much as possible to make sure that they had, the nonprofit mission took primacy over all other interests. And this is, they're running a business that generates revenue, and it's really easy for that to start to take over. And they really went out of their way to handcuff themselves here, to say we have to set this up so that the nonprofit mission always takes primacy over, the profit interests here. And that the nonprofit is sitting at the top of this, which gives, again, the attorneys general oversight over the entire situation, which are, well-resourced, very, it's law enforcement, right? They're giving themselves over to an outside force that absolutely has the power and ability to make sure the mission takes precedence. And for what it's worth, the reason we're having this conversation right now is because that's the case, right? If the nonprofit wasn't the nonprofit, and if the attorneys general didn't have the oversight authority that they have because the nonprofit sits where it does in the corporate structure right now, we wouldn't be having this conversation, because they could just make all of these changes and no one would have anything to say about it, right? So it's the fact that we're having this conversation is part of the reason we think it's so important for the nonprofit to stay in the position that it's in now, functionally, even if the letters after the entity names change.
Right. Yeah, that leads perfectly into the third point you make, which is you as attorneys general, because you're addressing it to them, would have limited enforcement oversight in this new arrangement. Yeah, can you explain why it is that by default, the attorneys general kind of would not be able to weigh in on what OpenAI, the business, was doing if they thought it was conflicting with OpenAI's charitable purpose, the nonprofit's charitable purpose?
Yeah, this will rhyme a little bit with the analogy of, hand on the lever versus deciding whose hand is on the lever. I mean, the attorneys general have oversight over nonprofits by virtue of the fact that, nonprofits don't have shareholders. They don't have other stakeholders that could make sure that they're adhering to their public, the charitable purposes. And so the nonprofits are then, for that reason, the state attorneys general are sort of set up as the overseers of nonprofits at the state level. And in California, there's a big statutory regime by which this happens. In Delaware, it's mostly just that nonprofit corporations are beholden to Delaware corporate law, and then the attorney general just has a special oversight authority over nonprofits that they wouldn't have over traditional for-profit corporations. And the reason that this is an issue is the PBC, right, is not subject to that kind of direct oversight by the attorneys general. Only nonprofits are. And so the PBC itself, unless it's doing something illegal that would implicate sort of criminal law in some way, the attorneys general wouldn't have anything to say about it. It's sort of up to the corporation, how the corporation does its things. And so, if the PBC did something that was contrary to its public benefit, the folks that would have the ability to enforce that would be the shareholders of the PBC. And it's worth noting here how little power that is. The Delaware Public Benefit statute, Delaware Public Benefit Corporation statute, was passed over a decade ago. I think it was 13 or something years ago. And since that time, there is not a single reported case of a shareholder of a PBC successfully suing to enforce the PBC's public benefit mission. And so you really are taking oversight from the attorneys general by if you remove the nonprofit from the situation and just focus on the PBC, you're taking the attorneys general out of their oversight position and replacing them with shareholders
Close
who
to nothing.
may or may not have
Yeah.
any power, and most of the shareholders that would have the ability to sue obviously are going to be more interested in putting their thumb on the side of profit motive than they are going to be on putting their thumb on the side of reining in the profit motive and benefit in furtherance of the charitable mission. So it really does hamstring things pretty significantly.
Yeah. Okay. So the attorneys general would be pretty significantly cut out of the loop, or maybe basically completely cut out of the loop. But it is the case that the nonprofit would be a shareholder. So it would, in principle, be able to bring a case and say, you're not doing enough to pursue the public benefit purpose. And you're just saying, well, they could try bringing a case about that. Good luck to them. Because in fact, like no one else has ever managed to successfully change what a business does on that grounds.
Yeah, I think there's a couple things to say about that. One is what you just said, which is it's quite difficult. So there's a thing in Delaware corporate law called the business judgment rule, which is basically, there's a lot of deference given to decisions by boards of directors of Delaware corporations, and that includes Delaware public benefit corporations. So it's just really difficult to sue as a shareholder a Delaware corporation for not doing what it's supposed to do. And in the case of the PBC, it's even more difficult to do it when what it's not supposed to be doing is, the public benefit versus shareholder interests. So I think that's like one piece of it. I think, another piece of this from purposes of enforcement is, you're suing for something that happened presumably already, and whatever impact that thing had has already happened, and you're suing, and, it takes sometimes years for these cases to get through the court system. So, you're talking about the difference between, I hear as a director that the for-profit entity is going to do something that would be bad, and I'm able to step in and keep that from happening sort of immediately, to that bad thing has been done, right? And then I'm filing a complaint in court, weeks later and trying to correct the thing when, for folks who are worried about the safety of frontier AI models, some of the harms that people are really concerned about aren't, once the cat's out of the bag, the cat's out of the bag, right? And so you really need to have that sort of front end, filter control instead of sort of like a back end, try to clean up the mess control.
Right. Yeah. So the new arrangement might be that if OpenAI, the business, deployed a very unsafe AI model that was contrary to the public interest, the nonprofit could sue in Delaware courts, and maybe 3 years later, the courts would come back and say, yes, we would like the business to weigh the public interest somewhat more when making decisions of this type.
Yeah, I mean, there's a broad spectrum of things that could happen, but like in general, yeah, the power to sue after the fact may be totally useless in this unique situation. And look, like, the fact that this is a unique situation and the technology that's at issue here is why it was so important. It's why OpenAI set themselves up the way they did to begin with, right? Like, they understood that this was a unique situation, and they put in a unique corporate structure, a very thoughtful way of trying to put these safeguards around it. And so we're just really concerned with trying to protect those now because of the situation is so unique.
It's the whole reason OpenAI exists. It's the reason It was a nonprofit at its foundation. It's the reason all of these very intense agreements were negotiated in 2019 to try to tie it to the mast, to like ignore that and say, well, actually, there's this is not the core issue today. Would be crazy. I guess it's perhaps a little bit challenging to bring the attorneys general up to speed on all this because there's so much history here, and they're not in the loop about all of these intricacies of AI concerns and like OpenAI's vision for the future and so on. But unfortunately, they do kind of have to get up to speed on this.
Yeah, I mean, that was like a big motivation behind the not-for-private gain letter from back in the middle of April, was really to lay out the history and build up to the current status quo situation in a way that like could help the AGs and other people who haven't been paying as much attention to this as like you or I have, right? To get them up to speed and I think give them the context they need to be able to understand that there's a reason this exists the way that it does, right? And that if you just turn this into sort of an off the rack sort of regular corporate governance situation, that could be really, really catastrophically bad.
Yeah, there's this difficult emotional issue here that I think some people are grappling with, which is through all of this conversation, we're saying by default. So we're saying if they don't take some major evasive action to avoid these outcomes, if they don't figure out all of these legal agreements and make them really watertight, then this is the way that things will go. Should we be so pessimistic or so cynical as to think that OpenAI is not going to do these good things that would pursue its charitable mission. Of course, there's many different actors. There's people who work at the business. There's the people in the nonprofit. There's, I guess, their legal advisors, and on and on. And I think many people have the intuition that, well, last week they made this big concession. They made this big change to their plans in response to the criticisms that we've been making. So let's assume some greater level of good faith than perhaps what we had thought before. But I think on balance, I would say they have kind of, like, this action has kind of conceded that they were trying to get away with a change that was illegal and that the attorneys general would not have signed off on. It was basically an enormous swindle of the public interest, of what things that the public owns and is owed in pursuit of the interests of other private groups. And I think if someone was like just trying to steal a whole lot of stuff from you, and then after a lot of public pressure, they decide that they're not going to try to steal that stuff from you anymore, they are going to propose a different plan, a different very complex plan that you find it quite hard to understand. I think one is entitled to be on guard, at least. Maybe we shouldn't be sure about what's going on and the views of the different people. But I think that it remains sensible to have a defensive posture here and not to assume that without any further scrutiny or any further discussion, the better angels will win out and all of these great things will happen by default. I don't think that we should assume that.
No, I think that's absolutely right. I think being on guard is exactly the right way to think about it. And I think just kind of keeping the pressure on is really important here. One thing that I was encouraged from the May 5th announcement is, and some quotes in the press after that, by in particular the Delaware AG's office, is it really seems like the Attorney General's offices really are paying close attention to this. And it suggests that maybe there's folks on the board at OpenAI who are tuned into this conversation, right? And might be like, really like listening to these messages. And I think that we should, be thankful that they are shifting gears a little bit, even as we stay on guard and keep the pressure on, and hope the folks on the board and the AGs do right by the situation, which again, I think will require a lot more doing. Like, it won't happen by default, given what they've announced now. Like, they really need to build in the governance safeguards into the PBC as much as possible. And it's a little harder to do that with the PBC than it is with the LLC. So I think that's, an important thing to keep in mind. Like, it is going to be more difficult to approximate the status quo with the PBC than it was with the LLC. And so, but I think, keeping the pressure on to make sure that as the restructuring moves forward, the governance safeguards that have been in place, and we can walk through what some of those are and how important they are if you want to. That stuff is not going to stay there unless a lot of work is done to put it there in the new structure.
Let's turn to solutions. So you have two asks for the attorneys general and the nonprofit board. So let's go through and elaborate on them and explain the impact that they would have. The first, which you think of as trivially obvious and absolutely necessary and the absolute bare minimum, is to include a primary fiduciary duty to OpenAI's charitable mission and charter in OpenAI PBC, the new businesses, certificate of incorporation. What does that mean and why does it matter?
Yeah, so the way that PBCs work that's different from the LLC. So in the LLC, you can just pretty clearly alter fiduciary duties of the manager in the LLC agreement. It's very malleable. We understand from what they've said on their website that they've done that, and that's the status quo situation. In the PBC, it's going to be a little bit more difficult to put that in place. And so what we really are asking for them to do is to use the certificate of incorporation of the PBC to bake in at least the level of primacy of the nonprofit mission as exists in the LLC. And, by default, the PBC, again, directors have to balance shareholder interest with the public benefit mission of the PBC. And so they're going to have to write something into the certificate that makes it clear that balance has to give way, at least in like critical situations, right? Where there's like, for example, the safety of a frontier model that's being rolled out, and write that in. And right now there's a reference to the charter. Now, the charter is a thing that's on OpenAI's website, and it has been on OpenAI's website for a long time, but that's really all it is right now, is a thing on OpenAI's website, unless it's incorporated into a document with real legal grip, right? And so the LLC agreement, as we understand it, based on what they've said on their website, incorporates the charter into the LLC agreement. So the LLC agreement says, you as the manager of the LLC are sort of obligated to put the primary, the charitable mission of the nonprofit, like the purpose of the PBC is to further that charitable mission, and it includes the charter, which expands a little bit on the charitable mission as it exists in the certificate of incorporation of the nonprofit right now. And in the PBC, they have an opportunity to do that with the PBC's certificate of incorporation and the articles of incorporation, and in a public place. In some sense, that would be an upgrade over the status quo, because right now they could probably just change the charter, right? And if they were to bake the charter into the articles of incorporation of the PBC, that would actually give it a little bit more legal teeth than it has now. So that's something we think should happen.
Right. Yeah. There's a couple of things here. So if you put a primary fiduciary duty to OpenAI's charitable mission and the charter as in the public benefit corporation's certificate of incorporation, does that mean that it no longer has to balance those values against profit, or does it still have to do that balancing act because it's a public benefit corporation and that's like their whole nature?
So this is one of the issues where there's just a lot of uncertainty, because there's not a lot of case law on what you can do with PBC articles of incorporation. So there's a lot of flexibility under Delaware law for what you can put into articles of incorporation. What the thing you can't do is do something that's contrary to law. So, there would have to be some balancing, because the statutes in Delaware, that's basically the description of what a public benefit corporation is and does, right? Is it has some balancing. So, one way you could imagine, and look, I'm not a corporate lawyer, I'm not the deal guy, and I think there's probably a lot of moving parts here and a lot of different ways that you could try to instantiate the sort of principles that we're talking about in terms of like keeping the primacy of the nonprofit mission and its enforceability paramount here. But I think writing it out so that there's balancing, but there's a really, really heavy thumb on the scale, right, of the public benefit mission, and especially in places where that's particularly important, given the unique nature of the technology here, is one way I could imagine doing that. But for what it's worth, like anything you do here could be challenged in court by the shareholders. And so, my understanding is that all of this is kind of happening in negotiation with investors and with the AGs and all of that right now. But, it is not as easy to maintain the status quo with the PBC structure because of the thing you identified, right? Because by statute, there still has to be some balancing involved. The question is like, how much can you put a thumb on the scale? How much can you make it more like the LLC situation without running afoul of that statute?
Right. Yeah. Let's talk about the charter a little bit. So the current OpenAI charter is this quite nice set of like values and commitments that OpenAI has made, that they've had on their website for a long time. I don't know how enforceable it is, and I also am not sure how it would. My understanding is that this is a charter written by the business, not a charter created by the nonprofit and imposed on the business. And as a result, the business could just change the charter whenever it wanted to, if it decided that it no longer wanted to follow that charter and wanted to do something else. So in a sense, it's both like very nice and also on very, very shaky ground presently. And I guess given that they've been promising us that they will follow this charter for all of this time, and it is, I think, an expression of the nonprofit's charitable purpose and always has been, and is quite a good version of that, we would like a very natural step up as part of this change would be to say, well, we want to put the charter somewhere that it is not so trivial to change, even if the nonprofit didn't want you to. And we would like it to have some legal teeth, some legal enforceability, so that if people just flagrantly violated the values and the stated goals of OpenAI, then someone could complain.
Yeah, no, I think that's what one. Like I said, to the extent there's both benefits and drawbacks of converting the LLC to a PBC. We've talked about some of the drawbacks in terms of the like less malleability, the inability to make it quite as a controlling a situation. One of the benefits is you have opportunity now to bake the charter into the articles of incorporation of the PBC, which would make them public and pretty durable. And you can in the articles also put in place, make it more durable. So you can make it harder or easier to amend the articles. And so like you said, right now, we don't know the extent to which OpenAI has told us on their website that they've baked the charter into the LLC in some form. Because we don't have the LLC agreement, we do not know the extent to which that's baked in and how, durable it is. And generally speaking, you can also make it pretty easy to amend LLC agreements. So my assumption right now, without knowing all the details, is that that's not very durable, right? And that it would be fairly easy to change the charter and make it, not enforceable. Unlike the nonprofits articles of incorporation, which are out there in the public, and those are enforceable by the attorneys general, right? So moving over to the PBC world from the LLC world, there's an opportunity here to take what's currently the charter on the website and whether or not it's, also listed out in the LLC agreement and made explicit there, rather than just referenced. You could write it out into the articles of incorporation of the PBC and really make it much more durable and more public and make it more of a commitment that it makes it harder for them to back off of. And I think that would be a really good thing and one of the benefits of moving to the PBC structure over the LLC.
Yeah. Yeah. Another interesting improvement that occurs to me is that, they could consider additional things to add to their charter, stuff that they might not have thought of in 2019, but now seem more relevant. For example, they talk quite a lot about the importance of OpenAI pursuing its work in order to ensure that AGI is developed in the United States first rather than in China. Maybe they should have some commitment that if it's necessary to cooperate with some other company or with the government or some other group in order to ensure that is the case, even if that conflicts potentially with their commercial interests, that is something that they will do because this is an important part of how they're hoping to benefit the public. I think that's something that would not have been so salient in 2019, but is very salient now and is the kind of thing that if they were reassessing the charter and considering stuff to add, then that would be quite natural.
Yeah, I think a couple of things in response to that. First of all, there is, I think in the current charter, there's the stop and assist commitment is the sort of shorthand we use for it, which is something like what you just described, right? It's like in the charter, they say if another safety-focused organization, gets close to AGI before we do, rather than race them to the finish line of AGI, we would, stop and competing with them and assist them in making sure that the AGI that gets developed, whoever develops it, right, is safe and benefits all of humanity. And, that's something that by default, if they move to a for-profit model and the PBC takes over from the LLC and the control that we've talked about goes away, it's not clear that would still be there. And so I think, writing that commitment into the articles of incorporation would be a great way of making that a durable commitment that they really have written into their articles. And by the way, that makes it so that everyone who's investing in the company knows about it, right? It's out there in the public. So no one's going to say like, oh, well, we invested and we thought you weren't going to, stop and assist one day. It's there. It allows you to say like anyone who's buying into this situation knows that this is what we're about. And they've kind of done that already, right? With like, you've seen the purple box on the website where, the people who invest have to like, acknowledge that their investment is should be made in the spirit of a donation, et cetera, et cetera. They've been trying to be really upfront about this and the PBC's articles could give them an opportunity to do that in an even more durable way. And part of what you said made me think of an important bit here, which is, this is an opportunity. Like, so we talked about sort of the cynical view of this thing, right? And staying on guard and keeping the pressure on. And I think that's really important. And for what it's worth, that's definitely going to be my mindset. And I think the mindset of a lot of the advocates that are working on this. But this is also an opportunity for them to do better, right? Like you could have a rosier view of this and say, look, like, stay on guard, but like, look, you could do better. Like you could, like you said, you could find things that aren't in the existing charter that would be good for the world and then write them into the articles now and make it even more protective. One of the things that we've been talking about in a lot of places is, just really like, the list of things that we put in the end of the not for private gain letter talks about just like really making sure the board is appropriately empowered and has the transparency that they need, the nonprofit board, to make sure that the nonprofit mission is protected. And so like you could write into the articles, really specific rules that make sure that the board is, has the right knowledge and understanding of the technology and the ecosystem to do their jobs right, has the kind of transparency and information flow that they need to actually exercise the control that we think they need to have in order to maintain the primacy of the nonprofit mission and keep it enforceable, right? And you could write those things in and make them even more durable and more enforceable. So I don't, we talk a lot here about like floors, like we think the very bare minimum that they need to do is X, Y, Z, but this is a real opportunity for them to do way more than the bare minimum and make the situation even better than the status quo. And I would encourage them and hope that they would do that. Yeah,
both for the board while their head is in this space and they're considering all of these different things, and there's potential to rewrite some of the agreements and improve them and pursue the nonprofit's mission even more. And also the attorneys general officers, they've got their head in this game right now. They're going to be getting their head across the issues. They can say, well, things have gotten a little bit unbalanced, right? Since 2019 through today, the business has grown so enormously, and the resourcing on the nonprofit that is meant to be scrutinizing it and ensuring that it pursues this charitable purpose has not really kept pace with that. And so we would like them to have both the personnel, the financing, the access to information, the independent ability to get advice without worrying that this is going to wind people up and cause problems for them, or all of that kind of thing. It would be very natural, I think, for the attorneys general to say these are the new arrangements that are necessary for this nonprofit to actually pursue its goals. So let's put them in place.
Yeah, I think that's right. And look, I think stepping back a little bit here, the nonprofit has a fiduciary duty to its mission right now, right? The nonprofit board members owe a special fiduciary duty to humanity as the beneficiaries of OpenAI's charitable purpose to ensure that AGI is safe and benefits all of humanity. And that mission applies to what they do right now, right? In approving whatever restructuring goes through. You know what I mean? And so the AGs have the power to enforce that fiduciary duty on behalf of the beneficiaries of the charitable purpose right now. So, there's it's almost like a meta point, right? Where like the very fact of what they're doing right now is subject to that fiduciary duty, and they have to be doing what they do now in furtherance of the mission, which is why I think, like you said, or as we've been saying, sort of there's a floor here. But maybe the best way to further the charitable mission through this restructuring is to do more than the floor. And I think they should do that.
Yeah. I mean, from the board's perspective, this might, for many of them, be their biggest opportunity ever to have an impact and ensure that the future goes well. And they, in taking on this role, it's a challenging role. Overseeing OpenAI is not a trivial task, but it's one that they signed on for when they became board members of this very important nonprofit. And it's, I guess, also in as much as they have a vision of themselves as a great people who want to make a positive difference and pursue the duties that they've signed on to. I really do hope that they put in the time and are willing to stand up to the pressure, because I'm sure there is a whole lot of pressure coming from the for-profit investors here who would love to basically redistribute power and money that the nonprofit currently has and take it for themselves. The nonprofit board should not give up its power and its resources so lightly. It belongs to these nonprofit board members on behalf of all of humanity. And they should be good stewards of that and not allow themselves to be cut out, not allow themselves to be screwed over by other people who stand to benefit by basically cutting them out of all of the decision-making procedures.
No, I think that's exactly right. Yeah, I mean, this is they have a really hard job to begin with. They signed up for it. Nobody made them do this. And I think it's a hard job day to day to manage this nonprofit. Like it really is, not many nonprofits are sitting on top of a $300 billion business empire, right? That's a really hard thing to do. And, this restructuring is potentially going to really change how things work over there. And so it's within a hard job that's uniquely impactful and critical. I think it's a uniquely, critical moment, and one where I hope the board, and I trust that they're all hopefully doing this, which is like to put, like you said, sort of they owe a duty to humanity here. And I hope that they're like taking that very seriously as they look at this potential restructuring.
Yeah. One thing that is heartening is that they did, when they refreshed the board a year and a half ago, they really appointed some top-shot people. I mean, yeah. I think, if anyone could take this on, these people have experience across so many different areas. And I guess some of them have done things that are as challenging, maybe more challenging than this before. So fingers crossed. So the second request you had for the AGs on the board, which you think is definitely necessary, is to do one of the following two things. The first option is give the OpenAI nonprofit board powers over the public benefit corporation sufficient to ensure that the public benefit corporation's board upholds its primary fiduciary duty to the charitable mission and charter. That's option one, a little bit of a mouthful. Yep. And number two is alternatively include an enforcement regime in OpenAI, the public benefit corporation certificate of incorporation. Maybe could you explain how the first one would work first?
Yeah, so the first one I think is, again, there's probably a number of different ways that you could get there. But the idea is to keep the link between the nonprofit and the PBC strong enough that, when you, that the attorney general oversight that they have over the nonprofit then sort of filters through to the PBC, right? So that there's no disconnect. So that the attorneys general, in being able to regulate what the nonprofit does through its board, by default, like by doing that, it's also regulating what the commercial entity is doing at the same time. And so it's really just like creating the connection between the nonprofit and the PBC in such a way that link doesn't get broken, and that the attorneys general at least have power to oversee things at the level of what really matters, which is the commercial entity going and doing things in the world. And I think that's, ideal. Like that's like I said, the reason we're having this discussion is because the attorneys general have that authority, and it's led to this the ability to put pressure on the company to do the right thing here. So I think that's ideal. And like the AGs exist because they are an organization and an office that is beholden to the public. The public interest is their thing, right? And they have the power of the state behind them, which is obviously very important. So I think that's ideal. So that's what the first option would be, was just to like arrange the relationship between the nonprofit and the PBC such that the AGs have the same control that they have now with the nonprofit in charge of the LLC.
Okay, yeah, and the second option was to include an enforcement regime in the Public Benefit Corporation Certificate of Incorporation. What would that look like?
I think that could look like a lot of different things. I think really what this is saying is if things get restructured in a way that cuts out the AGs or limits their power in some important way. So like we were talking about sort of, the sort of like gap that gets created when you have the PBC with a separate board and separate fiduciary duties instead of the LLC that's just like a straight through kind of control situation under the nonprofit. If that gap is such that it really does put some limits on the AG's ability to regulate things here, then I think there has to be something that steps in to fill that gap. And so you could, in the certificate of incorporation of the PBC, write in an enforcement regime that would be there to hold the OpenAI accountable to the charitable mission, right? So, and what that could look like, just for example, and this is a hypothetical, and I think it could look like a bunch of different things. I think it needs to be someone who's outside of OpenAI. So you have like a true sort of third party, disinterested in the sense of not a part of the corporate structure of the organization. And the AGs are obviously that already. So you would need to approximate that sort of like third partiness. And then you have to have someone who's incentivized to uphold the public interest, right? So someone who doesn't have any conflicts, financial or otherwise, with OpenAI, who already has probably a remit to protect the public and to have the public interest in mind. And then I think they have to be there's sort of like third partiness. There's sort of the incentive is there, and then I think they have to be well resourced enough to take on one of the biggest corporations in the world, right? So it has to be the AGs kind of have that by virtue of their state power. If you're going to put this into a non-state powered sort of third party enforcement mechanism, you got to make sure it's got real teeth, right? And so the 2B request in the letter is sort of like meant to say, look, if something happens here where the AGs get disempowered, and we think that would be bad, there has to be something that steps in to fill that gap, and that has to be an outside, incentivized and sufficiently resourced enforcement mechanism.
Yeah, I could see the attorneys general being so on this path. They basically opt out of having further enforcement power, and they delegate or pass on that to some other body. I could see them being pretty reluctant to do that, given like who else would they think is sufficiently has the cojones, and who else has the ability to stand up to these incredibly powerful forces, already powerful, in future probably even more powerful, who will be arrayed against them. I would feel nervous unless it was a pretty potent entity that they were passing on this responsibility to.
I share your concerns. I think it is hard to imagine, setting something up that would have the same power as the AGs. I think, there's situations in the world where attorneys general rely on private enforcement. So it's not like this would be the first time something like this has ever happened. But I think that, obviously having the state behind you is really important. And I think there's, there's probably ways that you could structure this so that there's sort of like a two-headed monster where the AGs still have some role, but there's another enforcement that's a party that's given some power. And I think you can do this in a lot of different ways. without getting into the details on it, I think the easiest way to do it is obviously just to maintain the Attorney General's, current level of oversight, and that seems to be the easiest way to do it. And then, like I said, I think anything beyond that, it's really just like you need an enforcement mechanism that's like resourced and incentivized to ensure that the nonprofit mission takes precedence over, profit motives and shareholder interests and anything else.
Okay. Another thing that's on my mind is it so currently the nonprofit board can fire and replace the CEO of OpenAI. Do we need to ensure right in somewhere that they still have that ability to fire, the senior staff who are meant to be pursuing their goal if they're not doing so?
Yeah, I think so. I mean, by default, as we keep saying, if you have the PBC under the nonprofit, the PBC's board would necessarily have the ability to hire and fire the executive and the CEO. But in order to preserve that kind of control for the nonprofit, you would have to write it into the PBC's structural documents or something. That would not happen on its own.
Yeah. Is it pretty straightforward for the attorneys general to basically insist on all of these specific requirements as the restructure goes through? Is that just something that they have the right to do, to say, if we're not going to sign off on this, you can't do any of this stuff unless you do ABC?
Yeah, it's an interesting situation because I don't think that there is a requirement that either of the AGs sign off in advance on anything that OpenAI is doing. Obviously, the AGs have enforcement authority here. So if the OpenAI were to do something they didn't like, they would be sued by the AGs and have the power of the state directed against them, which nobody wants, which is why they're speaking to them now, about the situation so that they're not doing something that's just, buying themselves a lawsuit from an AG's office. But I don't think it's the case that the AGs are required to sign off in advance necessarily on this transaction. Given the current situation where we kind of know they're talking to the AGs, it's de facto that's probably the case, right? No one's going to do anything that the AGs object to. So in that sense, the AGs probably do have, the ability to direct things to some degree.
See. Okay, so it's not the case that in law they have to approve it ahead of time, but because they have this enforcement ability to object to things that they do after the fact, and I guess have them reversed, basically, and we think that the AGs know what they're doing, and they would have a very strong case and would be able to get their way almost certainly should that situation arise. Effectively, they do have the ability to insist on things ahead of time, and OpenAI is not going to do things that the attorneys general say, well, if you did this, we would bring a case and basically try to undo it.
Yeah, they certainly have a lot of power in that way. And look, like, Kathy Jennings, the Delaware Attorney General, filed an amicus brief in litigation where, she was like, look, if this needs to be enjoined, we can enjoin it. And enjoin just means, get a legal order to stop the thing from happening. So, certainly they've not been shy about, flexing that muscle and making it clear that they consider themselves to have the ability to stop this thing if they don't think it's going the right way.
Okay, yeah. So one of the requirements for the nonprofit is that a majority of its board members cannot directly own equity, cannot directly have a financial interest in OpenAI. Do we know whether any of them are on track to receive equity in the business after this sort of restructuring takes place? I mean, needless to say, if they were on track to receive a huge payday should these restructuring plans go ahead, it feels like that could influence their decision. And that's not really how charities are meant to work.
Yeah, to say the least. So to answer your first question of like, do we know? I think the answer is no. Meaning that I've heard rumors and there's been conflicting reporting about, at some point, there was a report that Altman was going to get 7% or something like that. And I've seen other reporting. Yeah, exactly. There's been other reporting. I think that reporting happened at a time where the valuation was like half or something of what it is now. But I think, then he said since then that wasn't true. Right. Okay, and so, there's like, rumor mill stuff, there's reporting back and forth. So I think the answer is we don't know if any of the directors are going to receive equity as part of the restructuring. Certainly, if they were going to receive equity as part of the restructuring, they should be recusing themselves from any of this decision making, or even honestly, probably even discussion, because that's such a direct, obvious conflict that it's hard to imagine that they wouldn't be held out of the decision making if that was part of the deal.
Yeah. Do you know if the attorneys general, maybe I asked this earlier, but can they basically insist on the publication of the agreement between the nonprofit and their LLC that details what the public is owed?
It's a good question. I don't think so. I mean, like, it is, the nonprofit, the LLC agreement is, not by default a public document, and nonprofits, although they have, a public remit in some meaningful sense, like, they're still allowed to have confidential information. I mean, they don't have to like open every book they have to everyone in the public, every nonprofit ever. So I don't think there's like some rule by which they would have to make that public. For what it's worth, I think given their duty to humanity and their mission and the unique situation here, I think there's a really strong argument that there's a good ethical or moral, argument that they ought to do that, and that could be really important. But I don't think that the AGs would necessarily have the power to force that.
Yeah.
For what it's worth, I think that agreement is very likely to become part of the evidentiary record. If Musk's lawsuit goes forward and that trial actually happens on the schedule that it's happening now, it's really difficult for me to imagine that document isn't going to be part of the record. There could be, if there's a trial, I suspect it. I mean, it's hard to imagine it wouldn't become, if it was part of the record of the trial, which I think is very likely, it seems very likely to me that it would become public at that point, because there's just a really strong thumb on the scale of things that are made part of a trial being public. And while this is like could be confidential or could be considered non-public by that organization, it's not like a trade secret, right? It's not the kind of thing where you would keep it protected from disclosure,
discovery,
even in a trial, right? Exactly. Yeah.
I see. One other thing that it feels very natural and desirable for there to be more transparency on is the valuation of different things that the nonprofit might be conceding. So they're on track to remove the profit caps that currently mean that if OpenAI becomes incredibly profitable, the nonprofit receives almost all of those like super profits, basically. Yeah. They're on track to get rid of those caps, which means that the profits would be, any such super profits would be more evenly distributed between the nonprofit and other for-profit investors, which I'm not actually necessarily against. But the nonprofit is like giving something up there, and it should receive like some cash or something else in exchange for that, because otherwise it just doesn't make any sense in pursuit of its charitable purpose. But how are they going to value that? Incredibly hard to value. There'll be lots of potential for people to potentially undervalue that if they were so inclined, if they stood to benefit from that. It feels like you really would want public scrutiny on how those valuations are being done, so that people can see whether they are in any sense reasonable, and whether the nonprofit that represents their interests, that is basically holding assets or like holding future potential assets on their behalf, on the public's behalf, whether they are getting ripped off or not. I guess it sounds like it might be challenging for the attorneys general to insist on them sharing any such valuations, but I guess they could.
I'm not so sure. Yeah, I think like actually like the AGs have quite a bit of power there, maybe, because I think the protection of charitable assets is definitely in the AG's remit, and in California there's a lot of statutory power around that as well, in addition to just the basic power of the AGs here. So it is going to be very difficult to approximate the cap structure if everybody's just holding stock in a PBC. So to your point, I think you've kind of said this just to make it a little bit more explicit, like what would have to happen is some kind of valuation now that puts a present value on, right, the potential future value of the profits after the cap. And, I've never seen any economic analysis of that by the company. And I think that's extremely important, because, they need to, being able to make sure that this isn't a giveaway of a ton of value from the nonprofit, which has a mission, again, to use that value for the benefit of humanity, to a small group of investors, certainly is extremely important. It's not something we focus on in this letter, but it's certainly not something that we're not going to focus on going forward. We'll certainly focus on it. And I do think that the attorneys general have a ton of power here. I think they have, the ability to ensure that the nonprofit gets, a fair price here.
Yeah. I mean, the other thing that they are potentially on track to give up is that currently, should OpenAI develop AGI in its assessment, then I think Microsoft loses access or loses its like control or its access to the model, and the nonprofit would control and operate that AGI for the benefit of all of humanity. kind of feels important that they have their right to that. And if they are going to concede that, that is quite a significant concession that requires some compensation. I'm glad it's not my job to put a dollar figure on the value of that.
Yeah.
But I would really like to see any such evaluation that is put forward scrutinized by all actors who, can speak to whether it is reasonable or not.
Yeah, and I don't want to totally give up on the ability to kind of keep some version, at least in the economic reality of it, like you say, of the nonprofit maintaining ownership or whatever you want to call it of AGI after it's developed. But I do think that is not something that is addressed in. Really, it's not addressed in their original restructuring plans. In the status quo, it's very clearly the case, right? That the nonprofit would have, control and ownership over AGI if and when it's developed. In the original restructuring plan, it's not clear what happens with that. And it's not clear what happens with that in their new, proposal as of last Monday, right? And so, I think figuring out how to ensure that AGI really does benefit all of humanity. It's pretty easy to say that you can do that when when it's sitting at a nonprofit where that's the charitable purpose of the nonprofit. Anything else, they're going to have to figure out how to buttress that to make that still the case, right? And I think, like you said, putting a price on that is really, really hard. And there's something about avoiding trying to put a price tag on that now, and really trying to make it, actually recreate the state of affairs as it is now, rather than try to put a price on it. Seems like the better way to do that from my perspective.
Yeah.
But I think by default, that would not be the case, right? And I think that's the important bit here. Like, something has to be done from here to make sure that happens. It's not going to just happen on its own.
Yeah. Yeah. One other quick comment I want to make but before we finish up is that I guess we can sound fairly hostile, I guess, to the for-profit investors in OpenAI in the way that we speak. But I think that is not the case. I am very happy for them to make tons of money out of this deal, in as much as they put their capital at risk and they're making difficult business investments. It's just that the whole thing was set up with charitable purpose. In as much as they're making profit, that has to be in pursuit of the purpose of the organization as it was set up. And indeed, it probably is to a large extent, in as much as OpenAI actually is pursuing safe AI that will benefit all of humanity, and that actual purpose is preserved, then it is in their interest to take a lot of investment from for-profit investors and to pay them out whatever rate of return is required to induce them to do that. Totally reasonable. I'm not against it. I invest in the stock market and I make returns, and I invest in some companies that have a stake in OpenAI, I guess. And that is all well and good. It just can't come at the cost of the reason that OpenAI was established, and indeed the public interest, which I do also have a stake in.
No, I think a good way of thinking about this is that currently, I'm also not against investors making money. I think that's good, right? And I think
absolutely
what needs to be made clear here and continued to be clear as we move forward is that investment in OpenAI is a means to an end. It's not the end in itself. And so for traditional for-profit, in some sense, making money for shareholders is kind of the whole game, right? That's the deal. And a traditional for-profit, the board has fiduciary duties to increase shareholder value. That's their whole remit. And this is not that, right? To the extent that OpenAI is taking investment here, it's a means to an end. It's instrumental in support of the nonprofit purpose. And that's what needs to be protected here, right? So it's not that, no one can make a profit. It's not that, it has to be, if money touches this, it's somehow dirtied it or something. No, they probably need a lot of money to do what they're doing, but it should be instrumental in service of the mission and not become the end in itself. And that's the thing that we're most concerned about, right? Which is why we keep, I keep saying words like, a legally enforceable, primacy of the nonprofit mission over all of their interests, including shareholder interests, is because I think, there's a way that this moves forward where you're on a slippery slope to the profits becoming the end instead of the means. And we want to make sure that they remain the means and not the end.
Yeah. I think to really stylize things, I think you have the nonprofit board who are by and large acting in good faith, and I think are by and large trying to defend the public interest against what is an enormous set of forces. I think potentially trying to persuade them to do something else or try to trick them into doing something else.
Yep.
And then you have all of these for-profit entities, corporations whose mission, in some sense, you can't condemn them because their goal is to make money. They're kind of following their fiduciary interest to their shareholders, which is to just earn as many returns as possible. It is maybe there's questions about whether we should set organizations up to basically just be focused on the bottom line in that way. But that is to some extent how we've organized our corporate sector. And so these businesses are acting according to their natural instincts.
Yeah.
But that means that the nonprofit board has to stand up against them.
Right.
They are going to take everything that they can. They will suck the blood out of this organization in pursuit of like their fiduciary duties, which is to a very specific group of people who own their company.
Yeah.
But that is not the same as the interests of humanity. The nonprofit board is the only 10 people standing between us and that. So I don't know. Yeah.
No, that's it. I mean, that's it. Like right now you have the board of directors of OpenAI, the nonprofit, as the stewards of the nonprofit mission. And you're right that there already is a ton of pressure, right, from investors and from partners to do what their remit is, which is to make money for their organizations, right, or for themselves. And yeah, the board of directors is what's standing in between that profit motive and the nonprofit mission. And again, that's super important. And then it's super important that the attorneys general are there standing behind them, making sure that they're doing their jobs right, as additional incentive. Because I agree with you. I think, there's no reason to think the board isn't trying to do the right thing here. But it always helps when you've got
backup.
Exactly. Even if that backup is a way of explaining yourself to folks who may not get what you're doing. Right. But yeah, I think that's super important. So yeah, I think, the reason we wrote this letter, the reason we wrote the Not for Private Gain letter, and the reason we wrote this follow-up letter is because, I think there's a memes out there in the press that this was like a big shift on May the 5th when this announcement came through. And as we've been discussing, I think there's ways this could turn out well, right? But I don't think that having the view that this was a big shift is really the right way to be thinking about this situation right now. I think what you said is like keeping your guard up, and then I added, I think, keeping the pressure on is the right way to respond to this, rather than think, oh, good, we won, the nonprofit's in control, we can all sleep easy at night. I think there's still a lot of work to be done, and I think that work needs to be done by the board, and it needs to be done by the AGs, and it needs to be done by the public advocates that are out there trying to make sure that the pressure is on, and that everyone who's a stakeholder, which is really everybody, right? Like this is a nonprofit that's designed to benefit all of humanity, right? Yeah, exactly. That the stakeholders have as much transparency into this and have as much influence in this as they can. So I think that's super important, and that's why we're doing the work that we're doing.
Brilliant. My guest today has been Tyler Whitmer. Thanks so much for coming on the 80,000 Hours podcast, Tyler.
Yeah, thanks for having me, Rob. Really appreciate it.